Good afternoon, everyone. My name is Mohammed Abduroaf. Thank you for joining us on the live webinar. It's done via Zoom. Today I have with me Daniella Mair. Daniella, how are you doing?
Well, thank you. How are you?
I'm really well, thank you. So how it works today, Daniela is wherever she is. I think she's at home. I'm at the office, and then we have something else happening. So we try to do this virtually as possible, as best we can. The generic topic today is child custody, child maintenance, and divorce. Daniela is a psychologist. She is a specialist dealing with various aspects regarding the health part of families, couples, children, etc., the mental health part. So she counsels a lot as well. Daniela, we have a special topic today. We spoke about it last week. I would like to deal with this webinar on the following basis. Let's deal with the problem first, which you are facing. We can discuss it, and then we can unpack it from there. Daniela, I believe you have certain issues regarding some of your clients have issues regarding parenting plans. We can start with that. But before I do that, welcome everybody. Please share this video if you are watching it, and you're welcome to post questions live on the Advocate Mohammed Abdullaouf Facebook page. Daniela, up to you.
So I think everything that we're going to discuss today is very helpful for a lot of people that may not even realize that they're dealing with a similar issue, and also to have in their back pocket for anybody that they might know that's going through it to be able to shed some light. So one of the main concerns or main misunderstandings, I suppose, with a lot of clients that I see, as well as a lot of phone calls that I receive, is what is a parenting plan? What part of the divorce process does that come into? What is mediation, etc.? So I think it's very valuable to just explain the process. So I have people who contact me for mediation who have not even started the divorce process yet. So I get a call like, I am planning on divorcing my husband, my wife. I need a mediator immediately, as soon as possible. When can you see me? And it doesn't necessarily work that way, because obviously mediation is a voluntary process where both parties have to come to the mediation with an open mind. And if the other party doesn't know yet that they're getting divorced, it's not a process that they can just be forced into or thrown into. So what I'd like to kind of get across is that mediation really works in two ways. The one way it would work is if the couple have come to an agreement that they are going to dissolve the marriage, and they kind of agree to the fact that it's going to be dissolved, then you can seek private mediation where you both come in on the same footing. We can mediate, we can discuss the parenting plan, what care and contact arrangement we're going to come up with. We can deal with maintenance issues, put that all together in a parenting plan that gets signed by both parties, and then they can go off to the court to go and annex that to their official divorce order. The other kind of mediation that I experience is when a couple decide that they're going to get divorced, whether it's consented or not, and they arrive at the court for their divorce hearing and they have not yet come up with any form of parenting plan or agreement, then at that point in the court involvement, a court order can then be mandated that they will have to go and seek mediation and then come back after that with their parenting plan that's been signed off. So those are the two ways that we deal with mediation. And people who generally phone and say, I need a mediator now, I want to divorce my husband, I rather than steer them towards a divorce or marriage counseling environment where that can be discussed between the two parties and then introduce the mediation into that. So that is one of the biggest questions that I get asked.
Yeah, we get a lot of queries as well where people believe they can get divorced without even involving the other party. So come into our office, getting divorced, don't get the other party involved, and that also happens on a regular basis. Interesting to note, the High Court came with some new rules at the start of the year, just before COVID-19. And in there, I think it's Form 27, I speak under correction, which form it is, where if parties are litigating in any matter, they need to file a note, a form stipulating whether or not they are willing to agree or disagree to mediation. So it's a new thing. It hasn't been. I don't think it has been practiced so much because of the lockdown, and many court cases didn't proceed. So if the parties in the form stipulate that they are willing to do mediation, then later on in the court process, the parties will be sent to mediation. So mediation is a very important plays a very important role in litigation. All matters, not only family law matters. We're talking about commercial matters and so on. If a party is not willing to partake in mediation and he has no good reason and grounds for that, then the court can make an adverse cost order against him. So he can pay the other party's legal costs because he wasted a lot of court time. So Daniella, you as a mediator, you became more relevant now recently since the lockdown came into operation. Daniella, I'll start with one question to you. When parties come to you with their own parenting plan, what is your general view regarding that? Is it a good thing or bad thing? It comes to my office a lot.
It comes to me a lot as well, where I'll get a couple that come for mediation and they're just, to be honest with you, I don't understand really what they're trying to achieve by coming to me with their own parenting plan, but they do it. It is a great thing when you have people who understand the process and understand the benefits for their child to have access to both parents. But I do sometimes get clients that come in with a parenting plan that makes perfect sense to them in their situation, without having taken into consideration the effects on the children whatsoever. So although I really do appreciate people who do come in with their own parenting plan, and I'm saying their own parenting plan is there's no outside influence by any professional, it's just what they think is right, because they at least come with an idea of the fact that they do need to have this resolved, and with the ideas of what would work for them. So it gives us a nice foundation to work on. But I would ask those people to have an open mind so that we can actually discuss it point for point and see if with the third party's point of view and a professional point of view, if it is actually relevant and in the best interest of the child. So yeah, I think it's coming in with a parenting plan yourself is almost like coming from a more educated standpoint, if that makes sense. Yeah, but they must be open to flexibility.
Yeah, so the difficulties I sometimes have if people come to their own parenting plan, it's fine, it's good and well. It means that they have discussed the issues and they have, come to some type of an agreement. But many times they do not understand the problem that could arise if a parenting plan is not properly drafted. And most of the people that come to me post divorce or post dispute resolution, they come to me because they have speedily drafted a parenting plan or not well, or never drafted a parenting plan very well. For argument's sake, let's say back in the day, people used to stipulate in a in a consent paper, the mother will have custody and the father will have rights of reasonable access. That was fine many years ago. You can't put that now in a parenting plan. Now you need to unpack everything correctly, dealing with extramural activities, dealing with school holidays, dealing with public holidays. What happens if one of the parents are sick, etc. So we all know that each family is different. Therefore, they need to sit down with you. So maybe the bare minimum we can benefit from somebody coming with a parenting plan, they can at least advise us, okay, the mom will have primary care, the dad will have contact, etc. But I believe people need an assistance of a professional, especially when if there has been problems in the past. Daniella, that was that. I got another question, maybe a question of a comment regarding this. If a party cannot, this is what happens a lot to me. People email us, they contact us and tell us, I've been busy litigating for the last 2 years. My husband does not want to sign the parenting plan. Now that's a bit confusing to me because nobody can be forced to sign a parenting plan. You can't force somebody to do that. If the person doesn't want to sign a parenting plan, the court will come in and make his own parenting plan. Do you sometimes get those type of problems where people come to you and say he does not want to sign the parenting plan? And obviously he might have good reasons for that. He might want to have custody himself, or he might want to have more contact or less contact. I don't know. Do you get with those? Do you deal with those type of issues?
I do deal with those type of issues. Luckily, I haven't dealt with too many of them, but I have definitely experienced. And yes, you're quite right that if you get to a point where they just cannot agree, then the courts do step in and take over. And I mean, like I said in our last session together, that the High Court is the supreme guardian of the child. And if you can't come to an agreement with the parents, then the court will definitely step in. So I think that a lot of the time, the bigger problem that I experience is that the one party won't even show up for the mediation. So we don't even get to that point of the parenting plan. and they feel like if they can fight it in court, then they'll have a better chance of getting what they want, or of winning, because they've obviously employed a lawyer to fight for them at all costs. So yeah, it is a very tough situation, and like you said, you can't force somebody to sign something, and this is why I take the approach that I do to kind of coach people through the process and make them understand that it's about their children. And I think when you present, well, in my experience at least, when you present somebody with the facts that by you not signing it, let's unpack why you don't want to sign it. And if we find there's something relevant, then fine, then I'm all for that. But if we find that it's just a case of ego, and we can sit down and unpack the theory behind the parenting plan and the best interest of the child, 9 times out of 10, we do come to a resolution, because they realize that it just shines them in a bad light as a parent, you know, and they realize that maybe winning the ego thing is going to be more damaging long-term to the reputation of the child's parent.
Yeah, and I think many parents, not many parents, or some parents at least, once they are in a battle with the other party, with the other parent, they are now separated, they live in separate homes. It's like they now putting on boxing gloves, fighting gloves. They might believe or might know that going to a mediator, going to a psychologist, a social worker, etc., might be best. But they also do not want that. They want to follow a route where they can guarantee a win. And a win is not necessarily what is best for the child. So if a father has that attitude, and his attitude is, I would like to have custody over my child, I do not want to go to a mediator, because the mediator might, you know, be logical and sensible and might advise against it. I want to go to court one time, because I believe my lawyer will, as you said earlier, my lawyer will fight for me, will put my version forward, and these mediators and these social workers, etc., what they will do is they will basically find, you know, a favorable solution, which might not be what I want. And ego comes into play all the time. And I had a tweet now recently where somebody asked me the question, should I go for mediation, or wouldn't it be best to go to the office of the family advocate? This person was obviously not very educated regarding the differences between going to a family advocate directly and going to a mediator specifically. My view is that family advocates, their job is not to mediate all these thousands of issues in Cape Town. They're here to deal with matters where the High Court appoints them to do investigations. An advocate's job is not to mediate. If you want to go to a mediator, you appoint a mediator, a social worker, a psychologist, somebody that's with FAMAC, like yourself, accredited with FAMAC, and they will mediate the matter.
I just wanted to say one thing, sorry, on the previous point that you made about coming into mediation with a parenting plan. What I think I'm going to do, we haven't discussed this, but I have got a very nice, not a template, but a very nice form of points that should be addressed and covered when you're drafting a parenting plan. And what I'm going to do is I'm going to send that to you to post onto your pages for your audience, so that they can see if they do want to come in with some preparation, that at least they've covered all the bases.
Yeah, that will be very useful, because people do not know what to put in a parenting plan. The same way people do not know what to deal with in a consent paper. And a consent paper, what usually dealt with in there will be personal maintenance for couples, pension, the cars, the property, and stuff like that. Whereby a parenting plan it's quite a novel concept. It's not a concept which came about very recently. It came to operation, I would say, most probably just 10 years ago, where Section 33 of the Children's Act specifically said that if a parties can't come to an agreement regarding parental rights and responsibilities, are experiencing difficulties, they must enter into a parenting plan. So that's the first time the clause officially came into legislation. Thereafter, you received many versions of what would be a parenting plan until we come now. We're still developing it now, because now we stopped using the word facilitator, and we're using the word now parenting coordinator. So the law has quite developed, and I think it will develop even further and further as we go along. So, Daniella, thank you very much. Thank you very much. I appreciate that very much. And I think maybe at our next webinar next week, we can put that parenting plan on screen. I think I'll do that first. Then you on your side via Zoom, you can go through that parenting plan, and we'll obviously have a link where people can download it as well. I think. What do you think of that idea, Daniella?
Great idea. That's a great idea. Yeah.
Okay.
It's great. And it will also, while we're doing that, you can also understand the process a little bit better. A lot of people, like I've said before, come in with absolutely no idea of what to expect. And I think that the fear of the unknown is also what causes a lot of anxiety and tension. So just like ironing that out, I think will make everybody's lives easier.
Thank you for that, Daniela. Daniela, we have one comment. It's a comment. It says, very useful. Thank you. Thank you for that comment. Please note you are welcome to this webinar. Will take place for the next another 45 minutes for 1 hour. If you have any further questions, you want to pose questions to myself on legal issues or Daniela as well, legal issues, counseling issues as well, please feel free to post it. These questions usually come towards the end and then we have to rush to finish it. So please post it as soon as you can. Daniela, I got another question for you, and you can maybe advise me if I'm right or wrong. How many sessions do you think it's necessary for parties to come to a parenting plan? In my view, to be, they meet with you either singly or together. They unpack the issues. We understand what the issues are. We know the issues isn't maintenance. The issues aren't this. It isn't that. The issue is basically weekend contact and whether or not grandma or grandfather can have contact with the child. We crystallize it. But at which point do you work out that it can't come, this matter cannot be finalized? People are fourth meeting, the fifth meeting. At which point would you say people must go to court?
So this is a very open-ended question, really, and it's unique to everybody. But I think just drawing on my experience, you know from the beginning exactly what kind of couple you're dealing with and what kind of personalities you're dealing with. So very often, I think probably about 60% of my clients have literally walked into my office, and within 2 sessions, we've had a signed parenting plan, which is wonderful. But for the other percentage of clients, I would say, like, you can't really say what the average number of sessions are, but what I like to do is in the first session, I like to first kind of hear each other's points of view, and I always make sure that my clients leave with something, or with the promise that I'm going to email them something after the first session, so that they can see that the process can actually work. So what I do is in session 1, and I get an understanding, I always make sure that I deal with the less important things. For example, it's obvious that on the father's birthday, the child must be with the father. So that is something that the mother cannot really argue about, and it's 50-50 because on the mother's birthday, the mother will get the child. So let's get rid of all the issues that are not going to cause any tension and slot those into the template, let's call it, of the parenting plan. When they go away with that and they realize that nothing happened to them, they didn't get into trouble, that they weren't harmed in any way after the session, then slowly they start easing into the process, and it gives them time to also think about what they would like in the balance of the points that we need to cover. So when they come back in the second session, I often find that they're a lot more open to the mediation and are willing to negotiate a little bit more. So usually on average, I'm going to just say, I would say around about 3 sessions. It's like the average of coming to an amicable agreement. I think by the 5th session, I would send them off, because ethically, after 5 sessions of listening to people argue, it's not fair for me to continue seeing them and taking their money when I know exactly which direction it's headed. So I think maximum 5 sessions, unless you realize, like I did mention in one of our previous sessions about a couple that was in mediation for 10 years. When you identify that there's a reason other than mediation that they're coming together and they both want to continue on the process, that's a different story. I don't know if you remember the case I'm talking about, but it was very obvious that it was the only time they got to spend together. So they liked to come from their mediation session. It was once a month or whatever it was. And that worked. That turned to be more of a psychological process than a mediation process. So it was just named. But I think after 5 sessions, I would definitely call it or refer it or see how else we can work around it.
Yes, I think also when we're dealing with litigation, let's say somebody does not want to go for mediation and we try to resolve the matter. So usually we will draft a parenting plan based upon what we believe our client wants and what is workable under the circumstances. Because if parties don't sit together in the same table with a mediator like yourself, nobody will know where we are. They're talking past each other because of all the conflict and all the anger they have with each other. So resolving that matter, the best way in our view would be to draft a parenting plan based upon what our client believes is best and present it to the other party. Now, should the other party have a look at it, they can come with counter proposals. That's fine. That's step number one. As much counter proposals as they want to, but they need to come with something. But if we go up and down all the time, where the parties are nitpicking, we from 12:30, we're now arguing between 15 minutes. No, it can't be 12:30. It must be 12:35. Then we know these parties are not going to settle this matter. One party's duty and their job and the obligation is to delay this matter. So what generally happens is, and I wouldn't advise the client this, but I can think this strategically possible. If I want to avoid the other parent from seeing the child as long as possible, and it's still anything in my case. So if the other party never saw the child most probably for 6 months, okay, yes, we want to enter into a parenting plan, but I delay it. I say I want to get a lawyer. I take longer, I nitpick, etc. A year goes by. It strengthens my case to limit the other party's contact. Therefore, I would say up and down maybe 4 times, 3 different versions or 4 different versions of a parenting plan where both parties had 2 opportunities to amend their versions. If they cannot come to an agreement, if it's a minor thing, which then I would advise the parties, let's have a roundtable meeting and let's discuss these 2-3 points. But sometimes it happens, and I don't know if you have that problem, whereby if a party concedes to another party, let's say the mother wants X, and she fights tooth and nail to get X. And finally, X is a small finger, and finally he gives her the small finger. Then she thinks, oh my gosh, they conceded. Let's not go for the whole hand. And it happens on both sides as well. I don't know if you experience that already in your mediation sessions.
Yes, I do. Just touching on that, like I have had a case recently where the mother withheld contact for 2 years from the father. And you're quite right that strengthens their case, because no mediator, no family advocate would say, yes, you've got rights and responsibilities to your child, we're going to award that now, you can have 50-50 automatically. But it wasn't the father's fault. The mother was, in this case, the mother was withholding the contact. So, I mean, there are a lot of things that we have to consider, but there really are 2 kinds of people in the world, I think, when it comes to mediation. We get the ones that, like you say, you give them the baby finger and they take the whole hand. You get the other kind of people who, because the one gave the baby finger, they feel like they've won a little bit, and you know what, I'll give the other party something that's less important to me, that's more important to them. So I think it's very valuable to identify the personality aspects of the couple that you are dealing with, to kind of be able to guide them. And this is why we have mediation, is to be able to guide them along the lines of what makes sense for them. We're never ever going to get a narcissistic personality agreeing to something that is not their own idea. I mean, I'm just generalizing here, but it takes the professional mediator, and this is why I like the psychological side of the mediation in divorce, is because that person should be equipped with the skills to be able to approach the, like I'm saying again, the narcissistic personality, to be able to open them up in a way that makes sense to them, that's non-threatening. So when you have a legal situation, I mean, obviously you're paying your lawyer, you trust them entirely that they're going to fight for your best interest. And sometimes it makes more sense, and it feels easier to do exactly what you've just said and have your lawyer draw up a parenting plan proposal and send it to another lawyer. Because we know within ourselves that if my lawyer has given it to me, then it must be okay. We just assume that that's the truth. And I mean, they are employed by one party to represent one party. So it does make sense. And I have also had a situation where it did go back and forth between lawyers, where eventually there was still no resolution. And what happened was we did have a roundtable where we got the lawyers and their clients together. So it was the 5 of us. They each presented their case to me. And then I decided after that to go and collect the collateral from the schools, from the other social workers had been involved. And in that kind of a situation, they decided, you know what, we're still working on the parenting plan, but we're going to appoint you as a parenting coordinator, which gives you a little bit more involvement and a little bit more power. And then from that, I could then make a decision and back it up in a way that the lawyers realized that made the perfect sense. And then they went back and explained that to their clients. So nobody there felt like they were attacked. And I mean, one of the biggest problems I have is, as opposed to a lawyer, is because I'm always contacted by one person first. I think I mentioned this last time, there is always that feeling from the other party that there must be some sort of bias. And I completely understand that. And I can tell you till I'm blue in the face that that's not the truth, but it's human nature to feel that way. So I think sometimes coming in with a legally drafted parenting plan is actually a little bit of a help.
Yes, I'll start off from the last point you mentioned about if the father, for argument's sake, he looks around, he Googles, he goes to FAMAC's website, and so on, and he finds a mediator which he believes is capable of dealing with this matter better than other mediators because of cost-wise, etc. He'll most probably just contact you and ask you, can you assist? You say yes, and then just because he contacted you first, the other party will have a problem with that. But it's most probably fine with the other party doing the same thing, but the other party done it knowing, I don't know, that he or she believes that he or she won't be biased and so on. But it causes a bit of a problem. And it's very funny that once the parties go to litigation process, and the court maybe now says, okay, appoint your own mediator or your counsel, your psychologist to give a report to the court. Then they want, no, you pay for that person, no, you pay for that person. Now nobody wants to pay for that person because there'll be more bias if I paid your fee. I'm certain it's not the case, but no, more than likely you'll be on my side. But the people are very weird and they are very strange. Daniella, people have been posting. There's now two questions outstanding here. One dealing with child maintenance, one dealing with another question. I will deal with that a bit more later. So let's say 20 minutes before we end in the next 10 minutes time. Those who are watching, please post any questions you have so we can deal with them all, one after each other. And please feel free to share this video. Daniella, I must say, and I'll be honest with you, you deal with these type of matters very well. You come across, and it's factually correct as well, that you have a lot of experience regarding mediating between couples, parents, and so on, which is very invaluable. And it's hard for me. Sometimes it's very hard for me as a professional, as a practitioner, to find someone that can assist me in a matter. And luckily, you also tech savvy, and you're welcome to come online. It's one thing seeing somebody's CV online, going on the website and seeing somebody's CV and getting an impression from that person, as opposed to seeing somebody answer these type of questions. I can draft the most beautiful CVs online. It means nothing. People want to see your interaction and how you deal with the matter. And I must say you're really good on the fly. So thank you for that, Daniella. Daniella, one last question maybe before we start dealing with the other aspects regarding this. The Family Advocate's Office, what is your view on their specific role to play when it comes to child custody disputes? Obviously, they'll ultimately try to assist the parties in getting a parenting plan. But what is your view, the difference between the Family Advocate's Office, what they can offer, and what private social workers and psychologists and counselors can offer? I have my own view on it. My view maybe is, for example, that the Family Advocate is usually court appointed. So the court would appoint them, and they'll most probably be perceived to be a bit more objective because the government is paying for them. But I cannot see the difference in quality coming out over there. What is your take on that?
Okay, so I'll answer this with absolutely zero disrespect to anybody. But I do feel that I understand what you're saying, that they do come, they work for the government and might be a bit more objective. However, because it is their day job, I also do feel like there's a little bit of passion that's lacking. So I feel that in private mediation, I mean, I take myself, for example, I've worked for the last 10 years trying to build up my career in terms of following my passion, that is what I consider my life's work. I want to be 90 years old at the top of my field, still helping. And I think that when you do go for private mediation and private therapy, again, I've mentioned this previously, is you're not just a number, and you're not just, this is your case file today, this is your workload, go and report back. We take on our clients in private practice, and we have the opportunity to learn about them, to grow from them, to learn from them, and to kind of, in an empathetic way, but without taking it on, we kind of involve ourselves in their lives, So although the objectivity is kind of like, I do agree with you that it is more objective probably with court-appointed mediators, I often feel that we have a better understanding of the entire family system in private. We also aren't governed by how many cases we have to get through. I mean, I can have a serious matter and I can say, okay, for the rest of the month, I'm not taking on any new clients because I need to give this my full attention. And a court-appointed, sorry, I had all that feedback to me, a court-appointed mediator or social worker, and I mean, I have so much respect for them because they have a lot that they need to deal with and get through, and it's not easy, especially if it's court-ordered. But then, like, really, you've got the designated amount of time that you can spend with everyone. Back to the family advocate's office, when I was going through all of this, and I wasn't 100% sure of the role of the magistrate and the advocate and all of that, it was explained very nicely to me, is that the magistrate is there to sign the final order, but he cannot be, or she cannot be, everywhere at once and will not sign anything. The same way you can't force someone to sign a parenting plan. Legally, we need to know what we're signing, and they cannot be everywhere to see that they're happy with the document that they're signing. So what they do is they entrust their power, I suppose, over to the social workers that work for the court to say, you go out and be the investigating officer in this matter. If you're happy with it, then come back. We can talk about it in a hearing or a court case, and then they can sign it. So that made a little bit more sense to me, what the actual process is. And it does make sense, I think, that the involvement of the social workers and of professionals who are registered and who have the capacity and the capability of making educated You're muted. Oh dear. Okay, so I was just really saying that the magistrate, who is kind of the person that's going to court order, like who's going to sign the court order, the official order. What I was saying is that they can't be everywhere at once. They can't see the relationship between the parents. They can't see if there's animosity. They can't see how involved the child is in school, etc. So they cannot just blindly sign an agreement. And that is why they send out the social workers or bring in the expert witness testimony and all of that kind of stuff, just so that they know that their due diligence has been done and that the professionals that they're trusting to help them with that decision have actually done the groundwork.
Now, Daniella, thank you very much for that. I must just apologize one more time for the technical glitch we had. I have no idea how that actually happened. But before I go on, I think I should just deal with the question that were posed before something like that happens again. I think, Daniella, there's a problem with doing things virtually online. If the internet doesn't work, you are dead. Something that's happened over there. So, Daniella, thank you for that. Okay, the first question is, how do you provide evidence of abuse? The person didn't mention too much detail over there, but obviously evidence of abuse could either be physical, emotional, or psychological abuse. My view would be to show the scars, if you have any scars, and if you have any emotional abuse, to outline that what happened. So if the person swore at you, the person embarrassed you, the person manipulated you, or belittled you, etc. That is how you will show abuse. Daniella, anything to add on to that? The question only said, how do I provide evidence of abuse?
So this is something that I deal with more often than not, actually. And physical abuse is easy. You've got scars, you've got bruising. You obviously need the courage to go and actually do something about it. But if there's any kind of abuse, I mean, you can go to the police station, you can open a J88, you've got a whole host of things that you can do, medical reports, etc. Verbal and emotional abuse, on the other hand, is, in my opinion, far more damaging long term if you leave it unattended to, but it is very, very difficult to prove. So there are various different things that we can do, and emotional abuse is probably the majority of my caseload. So what we do in that instance is, this is a time where I have one-on-one, this is more like a therapeutic intervention. We're staying away from mediation now, where I'll get a client that comes to see me because of the abuse and they don't know what to do about the situation, or they don't know how to get out of the situation. So it's a lot of therapeutic intervention. It's a lot of, I'm focusing on one client, not on being unbiased here. And we take their reports and we make an assessment based on what they've said and what they've told. When it comes to the court process and in mediation, I have this very often where I'll have one party needs mediation, doesn't want the other party to have access to their child, or they only want them to have supervised access because of the abuse. We then also open an investigation into why that party feels that way. And that's built up with a forensic assessment. We assess the child, we assess the abused, the victim, let's call. We interview the abuser, who 9 times out of 10, if they are being abusive, do not consent to that meeting. And if it gets bad enough, or if it is as hectic as clients present it to be, then the only other option in that instance is to suggest that they actually go and open up a domestic violence interdict and get a protection order, which will then also go through the court, and they'll have to go and stipulate why they feel they need the protection, and the magistrate will then decide whether there's any grounds to that or not. So it is very, very difficult to prove. In fact, unless we've got actual recording that the other person has consented to, I don't really think there is much proof that we can find. We do get witnesses who have experienced it, and they can sign affidavits. But other than that, people often think no scars means I'll never get into trouble. If I don't leave a mark, I won't get into trouble. But we are seeing a much more, especially with all this gender-based violence stuff that we're dealing with now, I think we are dealing with a little bit more of an open mind into the fact that this is very real and quite dangerous.
I agree with you 100%. It's usually those, the physical scars, it's obviously bad, but those things heal. It's emotional scars that take longer to heal, or take forever to heal. Daniella, before we had this technical glitch, on the issue concerning the family advocate, I think they're doing wonderful work and so on. But the challenge obviously is because it's government appointed. They're limited to the policies regarding when they should work and how they should work. Like as per reason now, the Family Advocates Office is still doing COVID-19 protocol, which is totally fair and correct. But there's a reason I would imagine why that is a huge backlog. They take many, many months. And many times, and not to talk bad about them, but maybe to mention something, the problem I have with the Office of the Family Advocate is they sometimes become very expensive for the purpose of litigation. They usually say we require 3 to 4 months to provide a report. We come on the record, we postpone the matter in terms of the court order. 3 to 4 months down the line, they provide an interim report stipulating we did not have enough time, we need to appoint someone else. Then we postpone the matter for another 3 months. It just goes, sometimes it goes on for an entire year to get a family advocacy report. Sometimes not. Sometimes it gets done very, very quickly. But that's a problem I sometimes have with the Office of the Family Advocate, and therefore I many times suggest to clients, let's get our own private psychologist, social worker, mediator, whatever the case may be, to provide a report, and maybe have the Office of the Family Advocate endorse it for us and have a look at it. But to have the Office of the Family Advocate do the investigation, visit the parties' home, contact collateral people, and so on. And obviously, usually the social worker does it, appointed by the Office of the Family Advocate, and the Family Advocate will obviously just double check it and endorse it. But be that as it may, it can take extremely long. 3 months is quite long. And that's where private social workers, private experts come on board. And the same way when people contact me and ask me, Mr. Abduroaf, do you do any work for certain, I won't mention any names here, so certain organizations where we pay a monthly fee. And I say, no, I do not do any work for them. And why do they not feel confident with their specific services? It's because it's subscription based. So the type of service they get it's really limited. You are just a number, as we mentioned earlier on. So those are the problems I have. But otherwise, there's a purpose behind the Office of the Family Advocate. But I also believe that they are very understaffed and under-resourced. The concept is good, but they require more staff to work for them. So let's move on to the last question we have. Please help. I took the X for back pay. We're dealing with child maintenance. I have been in and out of the court for 3 years. He keeps on changing lawyers. Eventually, the magistrate heard my case. She said she will email the judgment at the end of October. Of course, she did not. I have been in court trying to find out the judgment. I'm going again this Wednesday. How can I insist on judgment? I am emotionally broken. I think the quick answer will be that it's not a legal question. It's a magistrate that's taking too long to provide the judgment. Maybe the magistrate only writes his or her judgments at court, listening to tape recordings, maybe through a documentation. She doesn't bring it home. So there could be a delay there. You need to contact the magistrate, and if the magistrate is not doing his or her job, you need to speak to his or her boss and say, I need to get a copy of the judgment. Daniella, that seems to be all the questions. We have another 15 minutes, maybe 1 extra minute, seeing that we had a technical glitch. Anything you want to add on the issue concerning parenting plans? I like the idea. Next week we're dealing with the actual parenting plan. The cost of a parenting plan. Maybe let's deal with a general aspect. We don't have to give your fees or my fees. What is a person looking into? Let's say for argument's sake your hourly rate is 10 rand. So how many 10 rands does the person pay? For argument's sake.
So I think anything in private obviously comes with the fees. Everybody. Sorry, let me start a little bit further back. Mediation, as such, as a discipline, is not necessarily what is the word I'm looking for? It's not regulated. So we have got FAMAC, who is a body who have kind of regulated the mediation process, and to be accredited with them kind of proves that you are bound to their ethical code, and that you've done the coursework, that you understand what your job is, what you're there for, what the mandate is, etc. But as a discipline, it's not controlled. So when you look at something like therapy and counseling and psychology, you go to the Health Professional Council, and it says there what the recommended rate is. So let's say the recommended rate for a psychology session is, or counseling session, I think was 880 Rand or something. That is what you can expect to pay for that. Whether your chosen professional charges the 880 or whether they charge 1,500, which they are quite entitled to do, that is then now up to you whether you want to pay the fees or not. So what I always say is, if you are worried about finances, if you're worried about how much it's going to cost, do your homework and just phone a couple of mediators and see which one can offer you the best rates or who you connect with. And the beauty about a governing board like FAMAC, and I use the governing board part lightly, is that you are at least guaranteed to get a similar service from everybody that is on that page. So I wouldn't personally endorse Mr. X, who's down the road, who claims to be a mediator but is not on the FAMAC website, because I don't know what they've done and what experience they have. But everybody on the FAMAC page have done the same course. They have got the same information. We obviously have a program where we have to keep our accreditation, have to keep up with changes in legislation. We have to do workshops, we have to do meetings. I mean, it's a whole process. So there is absolutely nothing wrong with finding it's actually laid out very nicely in areas and then in profession. So you go on there. I mean, I'm in Atlantic Seaboard, so we'll say, let's find mediators in the Atlantic Seaboard. It gives you a whole list. It says whether they're psychological or whether they're legal, and phone a couple of them and see who you connect with. I mean, you can choose whoever you want to based on whatever you want, really. So long as we don't go into detail about why we need to mediate and cause that bias for the mediator, there's nothing wrong with phoning or with emailing to say, hi, I'm looking for a mediator, can you please let me know your rates? So I think I am going to go a little bit into my rate, but not really. Is that from what I've heard, I charge under this the average rate, and the average rate seems to be around about 1,000 Rand a session, just for an indication. I do know mediators that charge 2,000 Rand a session. So yeah, so I think that's basically, I think an average of 1,000 Rand is reasonable, maybe even a little bit on the low side.
Daniella, thank you very much for that, and thank you for your honesty. I'm afraid to mention my rates. People might, oh my gosh, it is so cheap. I'm kidding. Daniella, I think it's important for people to know that you are professionals and you have a mandate, you have a duty to provide the mandate. You have a purpose. So if somebody comes to my office, my job is not to listen to them. I don't do that. You know, I listen to you for the first 5 minutes, and after that we need to start getting results. Get somewhere with the matter. Many people, when they come to my office, they like talking a lot. If they believe that it's their job to explain to me all the information, and they know exactly what I require, and that's not the case. I know exactly what to ask you. You come to my office, after 5 minutes I know exactly what questions to pose to you. If I have those answers, I can find a solution, a workable solution, and we can go forward from there. The same way with a mediator, I can believe so with your job. You know exactly how to take this matter forward. So yes, the first 2-3 minutes they can speak whatever they want to speak, but you have a mission. Your job is to mediate this matter, to have a successful mediation. Your job is not to listen to the parties or to counsel these people, unless they come for counseling. That's something else. But you are here to mediate a parenting plan, for argument's sake, to deal with the issue concerning child custody, child maintenance, guardianship rights, relocation, potential relocation issues, whatever the issues might be. If the issue is having contact with the grandparents, that is the issue. Your job is to mediate that issue. Ask the right questions, stop whatever individual from saying something if it is irrelevant, but he's entitled to do that. I don't know how you do your work, but your job is to do your job, and you need to get paid for that. So thank you for that, Daniella. And my job, and many people might pose a question to me as an advocate, why do I not mediate? I don't mediate. I basically refuse to do any mediation courses and so on, because I'm not a mediator, I'm a litigator. And that's how I differentiate myself from the system. If mediation fails, I take the matter to court, I argue with the judge, I argue with the other lawyer. My job is to win my case for my client, and that's it. I got blinkers on. My client might be wrong, depending upon the case. Obviously, family law is different on how to litigate other matters. But my job is to fight for my client to the best I can. Your job as a mediator is try to mediate the matter the best as you can. I said a lot now. Daniella, we have a question or comment. It says the following: my ex refuses to sign the parenting plan. What can I do? I think I dealt with it early on. Maybe you can touch on it.
Yeah, we did deal with it earlier on, but again, we can only say that we can't, unfortunately, force anybody to sign anything. So if you are finding that it is not going to happen, that the ex is going to sign the parenting plan, the only thing you really can do is take the matter back to court and let the courts get involved, who will then appoint a social worker. I don't know what stage of the process you're in, but a social worker will then have to step in and kind of make the decision for you and for your ex.
So Daniella, my view on parties not wanting to sign on the parenting plan, there's many reasons why he doesn't want to sign the parenting plan. One reason could be, for argument's sake, they say the mother, in the parenting plan there's a maintenance clause in. I don't believe it should necessarily be in a parenting plan. I believe if there's a problem regarding child maintenance, there should be a clause stipulating that maintenance matter can be resolved in a maintenance court. But at least we can sort out the issue concerning child custody and so on. But let's say, for argument's sake, the mother insists that the father can only pick the children up or the child up at 5 o'clock the evening and drop him at 7 o'clock. Where he said, no, I want to have my child from earlier, from after school until that time. Why must he sign a parenting plan if the parties are two different sides of the equator? It's impossible. He shouldn't sign it. But a bit of word of advice to parties: the matter is in court. The courts are not always so friendly, and the court isn't on your side or on the father's side. And it might come about that the court will find something totally against you. And maybe bring an example here. We dealt with the matter about 8-9 years ago in Weinberg Court, whereby my client and the other party, we were litigating, and we came to some type of an agreement, but the magistrate specifically said, okay, guys, this specific case. So the agreement was basically my client retains custody, the father sees the child every second week in the normal stuff. My client was a bit, adverse to that, but I got it to a point. But then the magistrate said something very interesting. She said, in my view, this seems like a typical case for 50-50. Whereby, and our client did not want 50-50 at all. So she had a problem with 75-25, but we thought over there, wonderful, okay, this is the only way to resolve this matter. Agree upon 75-25, as opposed to running this matter, going to court, arguing this matter, and end up with 50-50. So what I'm trying to say, Daniella, is resolve this matter out of court. Once you go into the court arena, you don't know what will happen over there. You might get certain punches and so on, and it's best to avoid that.
100%, and you're absolutely right. And sometimes people don't realize. I've said this before. You think that just because it's your child that you have the full and final say, but it's not the case. And I think education is key here. You are quite right, and I've seen it happen before, where the mother will not allow the father the 25, even though she's got the 75. And all he's asking is something silly like, can I have the children half an hour earlier? And it's almost like karma in a way, where there's no real valid reason why he can't. It's just that she wants to be difficult. And then you go to court, and like you say, they end up saying, well, actually, now that you've presented everything to me, the father should get more than 25. And then the other party, in this case, the mother, would be like, I should have just given him the extra half an hour. So you never know which way. I mean, there's so many contingencies. You never know what kind of mood the magistrate's going to be in. You never know whether the magistrate or people who are involved have a certain direction in life where they want to equal parent empowerment. You never know what you're going to get. And so definitely, if you can keep it out of court, then 100% that's the best thing. And I think that a mediator would also mention this in session when hopefully we're mediating it first, where they say, I don't, 4:30, no 5, no 4:30, no 5. I've said before, sort it out, or the judge will make the decision for you, and one of you or both of you are not going to be happy with that. So there is a way that you need to be a little bit firm about it. But one thing that I've learned, which also separates therapy and law, is even when I write documents and I have a legal proofreader, and she's like, but just kind of like it's too much, is that as a therapist, we kind of get way too emotionally attached to every single point. Whereas, like you were saying, within the first 3 or 4 minutes of seeing your client, you know exactly what to ask and what is relevant. So the point is also, and it's so incredibly difficult when you're dealing with it and it's your own personal issue in your own personal life, is try your best to look at it as though you're a third party and try and be as unemotional as possible, because when you get the emotions mixed into the legal and the points and the maintenance, you're fighting a losing battle, because nothing is going to be good enough for you other than what you came in wanting. if you can put it aside and say, let's look at it from the outside and emotionally, then we have more chance of being able to negotiate.
Yeah, Daniela, what sometimes happens, clients come to my office and they want the bare minimum because they only think they're entitled to the bare minimum. So the father might say, I never saw the child, for whenever. The mother believes she owns the child. The one was probably married and they separated and so on. And he comes to me and says, I just want to see my child every second weekend, for 3-4 hours without not being supervised by the mother, taking the child to my home, to my parents, to my brothers, and so on. So the conversation starts off like that. Then, as we go on in the conversation, then we listen to the facts and we think to ourselves, but isn't it better for you actually to have custody over the child? Because the mother cannot care for the child. The mother is most probably problematic. She might be on drugs, whatever the case may be. But the fact shows the possibility of the father caring for the child because he remarried and so on. Then we send a letter to the mother saying we want X, Y, and Z, and she says no, and she was adamant she doesn't refuse. Then later on in the process, we decide no. Let's take this matter to court and let the father apply for custody. And he's successful at the end of the day. Just because, and maybe it's in the child's best interest, of course, it should have happened, but litigation could have been avoided, and the party was unreasonable, could have avoided that from happening. Daniela, we have 1 or 2 questions before we end off. Okay, many people saying thank you for answering the questions. That's wonderful. Thank you. You're welcome. The question is, can the court make a decision social worker has been involved but still refuses? I think we're referring here to the Parental Plan. Yes, of course, the court will have to make a decision. The law does not specifically say at all that you must take the matter to mediation. The law doesn't say that, or a social worker must get involved, or the parties must agree upon a Parental Plan. If the court needs to make a decision in the matter, the court will make a decision in the matter. And Daniela, here's one further comment, whether for the same person. He is a drug addict and doesn't want to have supervised contact. I have been in children's court for over 1 year. Yeah, that's what the person is saying. What is the issue regarding a party being a drug addict? Does that automatically mean you can't have contact, or must we look at the matter holistically and so on?
Yeah, definitely. We look at it holistically. We find out exactly what their capacity is. You can't just say this one's a drug addict, therefore they can't see their child. We need to understand what their circumstances are, what the environment is. Obviously, we need to make sure that the child is not going to be in any harm and be exposed to anything that they shouldn't be exposed to. So I think if this parent who is an addict has, I don't know, been part of a STEP program, or they're committed to recovery, or whether they're not in recovery, I mean, it's all relevant. So let's take, for an example, what I would imagine here is that this parent is a current using addict. Then I would say that they should not have contact with their child without supervision. And that is just to protect the child. I mean, it's as simple as that. So I would get the courts to appoint a social worker or a supervisor that will be there to not interfere with the access, but just to keep the child safe. But then when we look at a recovering drug addict or somebody who has actually put in some effort to maintaining recovery, we can't say to them, because of your past, you are not capable of being a parent. We don't do that. Similarly, if a parent has got a psychological disorder, for example, bipolar, and they are medicated, we also can't say, well, because you have a diagnosis, you can't see your child. So I think it's all up to the parent to prove that they are responsible for their children and for themselves, and that they're capable of providing the care. If they are, there's no reason to deny the access. Like I said, like a parent who has a psychological disorder who does not take their medication, a current drug user, those are all red flags, obviously, to enforce supervised contact.
Daniela, I am with you 100% where that is concerned. You can't put this one variable into the equation and automatically mean the child should no longer have a parent or have access to a parent. I believe a child should continuously have access to a parent, either via supervised, unsupervised, telephonic, or via video, depending upon the circumstances. But that's where we're going towards. If the person is a recovering drug addict and he or she does not use drugs in the presence of the child, then that's a factual thing. It's like many years ago, and the law changed. It's very, very weird. Many years ago, I done a few matters, and let's say the parties had an affair. One of the parties had an affair, and my client argument was, no, he or she had an affair, and therefore the court must find in our favor. But the client couldn't see the logic, because how does the affair with someone else, and your spouse having an affair with someone else, affect the child of actually having contact with with other parents. So these are things where people can't compartmentalize matters. They need to divorce certain issues. So if drugs has an effect on the child, wonderful, then perfect. Then you need to isolate it and fix the problem. But it's not something which you can be looked at in isolation. Daniella, another question. Okay, this is an interesting one, and one which I do get posed to me often. How can third-party access to children be restricted due to strange red flags? What mechanisms can be used for this? One general one would be where a party does not want the new girlfriend to have contact with the child. The person doesn't elaborate further. Maybe you can say something regarding that before I comment.
Just read the first part of that again. Sorry, it broke up.
No, so the comment is, how can third-party access to children be restricted due to strange red flags? What mechanisms can be used for this?
So, with my experience, this is a huge thing that comes up, and it's always, with all due respect, usually based on jealousy and based on ego. If there is definite red flags, i.e. the child comes home battered and bruised, or the child comes home screaming that they were left in their room all day while dad and girlfriend went shopping, that's fine. Then you go to the family court and then you open, what do you call it? Sorry.
No, complaint.
They can investigate that. They complaint and they can investigate that, and they'll send social workers, and they're very good with that. When it comes to, I don't think my child really likes it, I don't think it's fair that the child should spend time with a girlfriend and not me, I'm going to be replaced as mom, etc. That is where I would recommend a little bit of personal therapy, just to kind of like get your own self-resilience up and your self-worth and all of that kind of stuff. Moms, nobody can ever replace you as mother. Dads, nobody can ever replace you as father. People will come in and out of your children's lives constantly, but the relationship that you develop with your child and the care and attention you put into that relationship will reap the benefits of it. I mean, it's not a question. And I think that often adults put that onto children. Oh, is she nice? Do you like her better than me? Do you have more fun with her than me? I really encourage parents who are dealing with third-party access to just realize their place in the child's life, realize and understand and accept the fact that they will not be replaced. It's impossible to be replaced. And that going forward, all you need to do is rather say to yourself, like I do. I mean, I've got an ex-husband, I've got a son, I've got a girlfriend, not me, my son's exposed to my ex-husband's girlfriend. And my approach was, the more people who genuinely love my son, the better for my son. So her and I get on extremely well because it's not about me, it's not about her, it's about my son. And it's very difficult sometimes to actually put the ego aside and do that. But I'm telling you 100 times, 100%, 10 times out of 10, if you can do that and there's no basis for foul play, you will be so much happier for it, and you can actually enjoy the relationship with your child and the other side of the family.
Daniella, thank you for that, and thank you for bringing your personal circumstances. It helps a lot. People can relate to that. That's the hour. We went over the hour. That's it was a good one. We had a few questions, many questions, and we answered to the best as we could. Daniella, your details are on the screen. You can't see it on your side via the Zoom, but it's obviously online. Daniella, therapy, divorce mediation, FAMAC, BA honors, psychology, your registration number, your cell number 0661547696, and your email daniella.reeva@gmail.com, and the website www.daniellatherapy.co.za. If you have any queries, any questions you have, you want to enlist the services or want to speak to Daniella about any therapy issues, counseling issues, please make use of those specific details, and she's very approachable. As you can see, she's exceptionally experienced. Many people, they hide behind the computer and the website. With Daniella is one of the few people I know that goes live. These videos are not pre-recorded, it's live. It's like you're on TV with a small audience, so you don't pay TV license for this one. Thank you very much for joining us. Daniella, thank you for your time. And those people,
thank you for having me.
It was awesome. Next week we're doing it again. Daniella, I'll be putting the stream off, but just stay online for 1 minute. I will chat to you about something else. Those people who are watching this video, appreciate, and thank you for all the questions, and we'll see you next week. Have a lovely day.